So, this is in the matter of people of the state of Michigan versus, wrong docket. There we go. Bruce Anthony Love, file number 24-218. Let me mute my computer quick. Obviously my microphone. Okay. This is the date and time set for sentencing again. We had adjourned it. I have Dan Gumtow appearing on behalf of the Illinois County Prosecutor's Office and Matthew Murphy appearing on behalf of Mr. Love. We received a sentencing memorandum dated June 3rd of 2025. And Mr. Murphy, you stated you received a response today.
Yes, Your Honor. This morning I received a response and reviewed it prior to this hearing.
Okay, I did have a moment to view it. I have not received it yet, but I'll allow you to argue it, Mr. Gumtow. So when we were previously here, I don't remember how far we got. So Mr. Love, have you had a chance to read and review the pre-sentence report?
Yes.
Okay, and could you move that microphone to Mr. Love so that we pick up his audio good? So you've had a chance to read and review it?
Yes, right.
Okay, and you've had time to review it and discuss it with your attorney?
Yes,
Okay, are you satisfied with Mr. Murphy as your attorney and the advice that he's given you?
yes,
All right, Mr. Murphy, do you wish, and I'm not talking about the guidelines yet, but do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Your Honor, that's what's contained in our sentencing memorandum. That was the changes that we wish to make. I think that's where it ended last time, was arguing over the relevancy of the trespass and arguments about that. So we just continue that if those.
Okay, all right. Do you want to verbalize that argument for transcript purposes and the record so that Mr. Gumtow can respond?
Yes, Your Honor. So in regards to the matter, and I understand that the narrative of the offense contained in the pre-sentence investigation report is a summary from the probation department. But again, it's in the pre-sentence investigation report. So we do want to challenge some of it. But again, they weren't there at the bench trial. So I do understand that some things may be different than what we're trying to explain, or the probation officer may have viewed it differently. But the statement that Mr. Love had received a trespass warning back in 2023 from Erie Park, as I explained, that issue, I believe, is central to this, and I don't believe that that's correct. He didn't receive an official trespass warning. Officer Robinson testified at the preliminary examination and again at the trial that he had trespassed Mr. Love. We had requested documentation of that. I believe at the preliminary examination, actually, Officer Robinson testified that he had just told Mr. Love that there wasn't any documentation that he'd given or provided. We had a charge, a case against Mr. Love for that trespass. That was the case that Officer Robinson had basically charged him with after this incident that stemmed this case. That on that file, we had requested per the discovery, the documentation from the city of Adrian to Mr. Love documenting that trespass had never been received, and that case was dismissed. So again, our argument being that, well, Officer Robinson may have told Mr. Love your trespass from this park. We're arguing that wasn't an official trespass that could be carried with Mr. Love indefinitely for the future. So that was the argument on that, Your Honor. Does the court want me to continue with?
Yes, but hold on, Ms. Adams, I've sent a message to Tom Moore, but I need a probation agent to log on or come in. All right, go ahead.
Your Honor, and that's also central to this issue because it was that fact. Mr. Love has been dealing with this issue for a couple of years now, himself being trespassed from this city property and not being officially trespassed, not giving an official warning, or I'm sorry, an official documentation because of such. I don't know. I'm trying to get to the understanding of where this is coming from. If it's a policy that's put in place by the city, by the parks, or by the chief of police, for Adrian City Police Department, but this policy is involving people like Mr. Love and other individuals in the community are being deprived of their property rights, of dividing their liberty without due process, because they have no way of challenging that trespass moving forward. If what occurred here is, I mean, this is what my understanding would be, that Officer Robinson said, that trespass was occurred back in 2023 is when he said that. There's no end to that. And Mr. Love, and there's no criteria for that. There's no burden of proof or anything. I believe in this situation that in that incident, Officer Robinson had told Mr. Love, I believe you're drinking in the park and that you can't come to the park anymore. Now, obviously, that's something that I believe officers can tell a person they have to leave if they believe that they're violating the park rules or, you know, some other city ordinance, whatever. But that trespass involves them leaving at that time and coming back. They can come back in the future. The trespass only lasts at that point in time. Now, if Officer Robinson believes that he sees Mr. Love with a paper bag or a drink or, you know, whatever type of drink, and says, I think you're drinking, I want you to leave, and Mr. Love leaves, now that stems, Mr. Love now can never come back to Erie Park. He has, and as it is right now, he has no way of challenging that. So that's, Your Honor, what we're saying, that there's a fundamental violation of his due process of not just Mr. Love, but other people in the community, which is the issue here. And Mr. Love was trying to protest that at this time, because if you recall, Officer Robinson testified that he was there in the area, and if you call in the body cam, he was reviewing the previous body cam of that alleged trespass that he originally trespassed Mr. Love at. Officer Robinson testified that he was there, and Mr. Love was being loud. He was basically yelling at Officer Robinson. Officer Robinson testified at the trial that he stayed in the area in the hopes that Mr. Love would calm down or something to that effect. But it was his presence that was causing Mr. Love to act that way. That's why I had objected to one of the other statements that the child had said. Mr. Love was only acting that way when Officer Robinson was there. And so Mr. Love was protesting the whole situation, the fact that he can't even walk to the park. Again, he doesn't have a license to drive. His only way is to walk to areas, and he's now being told he can never go to these areas for however long he has left to live, which hopefully is another 30, 40 years. But that's the issue here, Your Honor, was that Mr. Love was protesting that. And that was why I thought maybe the narrative should have been changed to reflect that in regards to, again, what the child had said. And thank you, Your Honor.
Okay, so there is a statement, description of offense narrative, that states on May 12, Officer Robinson of the APD observed Mr. Love at Erie Park. He had received a trespass warning back in 2023. And I guess the language, and at this point, I don't know if they're saying on that day, the officer advised him not to be in the park. But Mr. Gumtoe, your response, please.
Your Honor, the people would contend that the trespass warning given by Officer Robinson, even if verbal, would be valid. But aside from that, if Mr. Love felt as though he had a valid reason to protest, we would argue that the park was not the place to protest. That the courts would have been the proper venue for that. That's our position, Your Honor.
Okay. Anything else, Mr. Murphy? So, Miss Holly, I know you're pinch hitting today. So if you go, there's a portion of the PSI under description of offense states that on May 12, 2024 at approximately 1500 hours, Officer Robinson of the Adrian Police Department observed Bruce Love at Erie Park. And it does state Mr. Love had received a trespass warning back in 2023 from Erie Park. So that was a warning. It was never a formal trespass he received. So I think the issue is based on that, it's just kind of convoluted, the paragraph. So I'm guessing it should say Mr. Love had previously received a trespass warning in 2023, period. And then that wasn't the basis to trespass him, is what you're saying this time.
I think it was the basis. That was the whole idea that Officer Robinson.
But it shouldn't have been.
Well, I'm arguing it should have been, but I think that's what Officer Robinson was going on.
Okay. All right. I think that trespass warning, so he wasn't formally given a trespass charge back in 2023, but there was some dispute at the time of this incident and then he was trespassed. I'm trying to remember.
I believe the verbal trespass was given in 2023, Your Honor, and I don't know beyond that. It would be our contention that a verbal trespass is enough. It doesn't have to be written.
And Your Honor.
Right, but if it's a warning, it's not a permanent trespass, right?
I would say a warning is probably not a permanent trespass, yes, based on just the language, Your Honor. I would agree with that.
All right. So I guess, you know, so I guess the language in the PSI just needs to state that he had a previous trespass warning in 2023 for Erie Park period. And then the officer.
Your Honor, I guess the question was that even relevant at this point.
Not really, but
My
I'll modify
argument. Sorry, Your Honor.
I'll modify the PSI to reflect that.
Because again, our argument being that their understanding, Officer Robbins' understanding is this warning, verbal warning does satisfy an official documented trespass moving forward. So at this time, still, Mr. Love, if he walks near Erie Park, he's going to raise the issue of maybe the police department. And so that's one of the problems that we have here is while in the PSI, you know, I don't mean to drag this on.
I mean, we can listen to the video again, but my memory, and I've had a lot of cases since then, is that he was, I mean, do we want to listen to that portion again, the initial portion?
I don't think we need to, Your Honor, because I think we're just going in circles. The problem that I have is that I guess it ultimately is the officer's belief that he has officially trespassed Mr. Love from these parks, I believe is relevant. But I think we're arguing over the use of the word warning here, which we would consent that a warning, a verbal warning was given. The effect of that is what we're arguing about.
Okay. But he was still trespassed again that day and advised to leave the park.
He was told the day of this incident, earlier that day, Officer Robinson said, you can't be at the park. Not for anything else previously, but for that 2023 incident.
Okay.
Not for anything he had done that day.
Okay. Anything else?
No, Your Honor.
Okay. Anything else you wish to explain or challenge in the body of the report?
Nothing further in that in the narrative, Your Honor.
Does pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Not that I can think of, Your Honor.
The guidelines in this case were computed to be, let me get back there. They were computed to be 0 to 34 months. Do you agree with that computation guidelines?
I do, Your Honor.
Do you?
Yes, Your Honor.
Before the court passes sentence, is there anything you'd like to say on behalf of the people?
No, Your Honor. Thank you.
Mr. Murphy, on behalf of your client?
Your Honor, we're asked the court, we understand that the recommendation is for some incarceration, a year incarceration suspended. I think the recommendation says suspend all but 30 days and maybe probation after that for a period of time. Your Honor, as we've spent quite a bit of time on
I don't see the suspend. I see 18 months probation, truthful report, 1 year in jail with credit for 3 days served.
And I think at the end it says the remainder of the jail term be suspended.
Yeah.
It's not in that part, it's in the second part. Okay.
Yeah, they split it up. But Your Honor, obviously, there's quite a bit here that I've argued in regards to the fact that Mr. Love, we've had a trial. We understand the situation. Mr. Love understands that the jurisdiction of the court that, you know, the trial and the way it did. But at this time, Mr. Love still contends that he was exerting his First Amendment rights. And I believe that he was doing so as well. Your Honor, with that, I don't want to take up too much of the court's time, but I believe a sentence that would be fines and costs would be appropriate in this matter, or suspending all jail time and just having probation moving forward. Well, Mr. Love, again, he does have a past criminal history. If you look at it, it's again, dark life suspended and conflicts with officers. And as I explained, this conflict with the officers seems to be far more than Mr. Love. I mean, it's not as though Mr. Love is broken into a house, they come to respond, then he fights with the officers. It's the officers saying you can't be at this park, or you can't walk on the street, or Mr. Love, stop, you know. The video that Officer Robinson was looking at was just Officer Robinson yelling out the window at Mr. Love. Hey, Mr. Love, you can't be at the park. Which, you know, so that's the environment in which Mr. Love is living. That's what he's dealing with right, in Adrian at this time. And so we'd ask the court to take that into consideration when passing a sentence. And I believe, again, the guidelines, they're 0 to 34, which allows a huge leniency for the court and what to do, all of which would be appropriate under the guidelines. So if the court was to do fines and costs or just probation, it's still within the guidelines for the court to do that, Your Honor. So I'd ask the court to consider that.
Okay. Mr. Love, anything you want to say on your own behalf?
Actually, Mr. Robinson, Officer Robinson been threatening me.
Can you move that microphone and I need you to speak up?
I said, Officer Robinson has been threatening me, been stalking me for the last 3 years, you know what I mean? I mean, I can't walk out my house, he parked in front of my house. I can't walk my backyard, he behind my house. He's doing too much, you know what I mean? I'm not the bad guy here. I just lost my mom. I'm still in recovery mode, you understand? And there's so much that he done put me through. All the money I had is gone because I had to pay all these court costs, different things that I ain't have no money for. But because he made me feel like I'm the bad guy, but which ain't doing nothing wrong. He kidnapped me, actually. Understand me? Man, why he? 3 of us. He always come up to me. Okay, who around? It's always me. I don't appreciate it. It's not right.
Are you, no, you have a cane, so I asked this, are you receiving Social Security?
Yes, I am. Let's go.
Your mom's funeral over?
Yeah, we got a lot of stuff. We got to move down south and take care of it.
Is it all done?
Yeah, we ain't done yet. We just, I'm trying to get there, and I'm instead of coming up here, like every time I go, like I'm coming back, you know what I mean? It's just so much of it.
All right, so this was a bench trial. The body cam, once it was turned on, actually was pretty good video and audio. So court did find him guilty. So, Mr. Love, you have a lengthy record, and Mr. Murphy's correct. It's not major offenses you've been convicted of. So in determining the case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. So it is a sentence of the court that you be placed on probation for 18 months. During that term of probation, not to violate any criminal laws of any unit of government, not to leave the state without permission of the court. Obviously, if your mother's funeral is going to be occurring, you'll just request permission. They bring it to me. Okay. Make a truthful report as required to the probation department. Notify them immediately about any change of address, not to engage in any assaultive, abusive, threatening, or intimidating behavior, not to use any object as a weapon. Submit to search of your person and property. That includes your vehicle, your residence, your computer, without need of a warrant if they have reasonable cause to believe you have items that violate the conditions of your probation. They can't enter your house for probation, just to verify you live there and enter your home for that. There's a crime victim assessment fee in the amount of $130. $30 per month supervision fee, $60 if they need to put you on a tether. Court costs in the amount of $350, $60. I don't know that we need a DNA fee. He's been on probation before, but If they had to redo the DNA fee, it'd be $60, $68 in state costs. So what I'm gonna do is give you 1 year in the Lenawee County Jail. I'm gonna suspend that. And I'm not gonna take him into custody today. So Mr. Love, I'm gonna suspend that year in jail and I'm gonna give you 3 days credit. Your guidelines are 0 to 33 months. So understand if you violate probation during that term, you're gonna do a year in jail, right? So, you do have the right to appeal this sentence. My bailiff's gonna hand down to your notice of right to appellate review. You're gonna sign 1 copy for our records to acknowledge your receipt of the documents if you wish to appeal your sentence, which I think there's some discussion with your attorney about something, but you need to fill out the paperwork and submit it within 42 days, and I think Mr. Murphy could help you with that. I asked about Social Security because if I was going to give you a jail term, it would have been less than 30 days because I didn't want them to stop your Social Security and make you have to reapply for it. I'm sure Mr. Gumto is not happy with me because usually on these, we do give a jail term, but in this case, I'm not going to today. So will you initial and date that? Just acknowledge you received your paperwork.
Thank you, Your Honor.
Thank you, Judge.
You're welcome. Record to reflect, I received back a signed copy of the notice of right to appellate review. All right, we're all set. Thank you.
You need to report to Mr. Moore Tuesday.
Tuesday,
Yes.
so between 8 and 10, report to Tom Moore across the hall, all right?
Thank you.
Thank you.
Thank you, Your Honor.
Thank you.
I pay the fine.
They do at halfway point. Yeah.
Okay.